Welcome to the Business Owners Council, Legal Issues from Growth to Exit.
Welcome back to the Business Owners Council, Legal Issues from Growth to Exit. I'm Evan Mack, and in each episode, we sit down with Kevin Brick, founder of Brick Business Law, a trusted advisor to Florida companies, to talk through the strategies business owners need to grow, protect, and maximize the value of their businesses. Today, we're talking about the business of litigation, how great attorneys help you make better decisions. Kevin, welcome back.
Thank you.
All right, Kev. So let's start with the bigger picture, Kevin. How should business owners really think about lawsuits?
Well, from the standpoint of making a decision about if you should sue somebody, if you're making a decision of whether to file a lawsuit, you should think about it like a business decision. It involves trade-offs, cost, time, risk. It's not just about being right, but it's about, how much is this lawsuit going to take away from my business? What are the risks? Is it worth it? If you're being sued, you don't have as many decisions to make. You're playing defense and figuring out what's the right strategy for it once you're involved with it.
So what are the biggest decision-making mistakes you see owners make?
A lot of the business owners, a mistake they make is emotional reactions to things that happen in lawsuits or even to being sued, expecting that the other side is going to lie and they're going to do things and they're going to say things that aren't true. You have to know that in litigation, sometimes that happens, and you just got to kind of take those things in stride. I think not anticipating the other side's tactics. Sometimes when somebody thinks they're going to lose or is under pressure, they may do things to delay or act in a certain way that you find to be wrong. And so, being able to anticipate those things and deal with them. And overestimating the strength of a case or underestimating the risks and costs and complexity. We talked, I think, last time about the sunk cost fallacy. So that's a big mistake I see is business owners getting 6 months or a year into litigation, feeling like it's a bad decision, but just saying, well, we're already this far into it, we need to continue. So those are things I would say are mistakes I see business owners make.
Can you walk us through a scenario where a case should have settled early, but, actually didn't?
Yeah, that comes up often. So, and this ties right into kind of making those mistakes, overestimating, feeling overconfident in your position or underestimating the costs and risks. So when an opportunity comes up for an early settlement or a resolution, an owner who wants to win or they want to punish the other side, oftentimes reject either a reasonable settlement offer or an opportunity to mediate or have a discussion about settlement because they do feel overconfident or they do feel like they can win the day. And so then as the litigation goes on, if it doesn't settle, costs, time, effort, all those things, they escalate and the outcome is still uncertain. And so there can be situations where a business gets hurt in other ways that they don't anticipate if they didn't settle early. So I would say the lesson there is just depending on the facts of the case, the early resolution is a tool that avoids uncertainty and it contains costs. And a lot of times that's the right way to go for a business that is trying to do things other than be in litigation.
On the flip side, though, Kevin, what about cases that settle too late?
Yeah, you hear about these all the time, right? Like cases that settled on the courthouse steps or actually even settled during trial or before a jury comes back. And whenever I see those types of cases, or are involved with it, that you got to that point after you spent a lot of money, a lot of time, a lot of effort building a case and getting it to that point. And whatever the settlement is, a lot of times that means the return on investment has been significantly reduced. And usually if it's settling at that point, that means that one party is probably not getting what they want out of the settlement. And it means somebody waited too long. So again, just kind of talking about the lessons about settling too late, the leverage points and timing that are optimal, they often go by during the course of the litigation. And so you got to kind of be aware of what is an optimal time to reach a resolution. Because if you don't do that, sometimes you do end up in the shoes of that litigant who's settling at trial on terms that they don't really want to settle on or right before. So having that conversation with your attorney, make sure that you're identifying opportunities to settle and what might be the best opportunity for you or your business.
How do opponents use delay as a strategy?
Well, you see it a lot. So a lot of opponents, especially if they have a weaker position or less resources, what they try to do is just drag out the case. make it painful to advance it, increase the cost of the other side, and maybe make them fatigued, putting in so much time and effort. And those are things that, unfortunately, they are effective at forcing settlement or concessions or bringing the other side to the table. And so, litigation, it's often just an endurance game. How much time are you willing to put in? How much money you're willing to put in? How much effort are you willing to put in? And the side sometimes that's willing to drag it out the longest, they're successful in some ways.
You mentioned leverage earlier. What does that actually mean in a lawsuit?
Well, just kind of going back to the last episode, we talked a little bit about what's the practical realities of litigation. And so you've got, on one hand, the law, right, which establishes the strength of the case alongside of a bunch of other practical considerations like the strength of witnesses and evidence. Another big piece of it is these leverage points, right? Which side has the financial strength to continue the longest? Which side has resources to commit more? Which side can, withstand the disruption that comes with litigation? So all of those things, they all relate to leverage. And so a lot of times leverage over the course of litigation wins, quote, wins more than the law does, because they make it people with leverage or litigants with leverage and find those pain points that cause the case to move in the ways that they want to.
So what does a strong litigation strategy actually look like, Kev?
A strong litigation strategy, it involves clear objectives. So maybe it's to win the case, but maybe it's other things. What we talked about, it's to delay an outcome or tie up a competitor in litigation. The actual litigation should be working towards a particular outcome, a goal. And so maybe within the litigation itself, you're working towards winning at summary judgment, or you're working towards having a ton of leverage for settlement, or you get an injunction. So a good litigation strategy should have kind of the big level goals, but also how are we going to win within the case? Other pieces, I think, are understanding a budget, how it's going to be allocated, what the timelines are. We talked about, identifying these leverage points that give your client as a lawyer a better chance to compel settlement or to get a good outcome. And then I would say also a big thing is just reassessing periodically. Cases change as they go, facts change, situations change. So making sure the strategy that was set at the beginning is still as good of a strategy as things change during the course of the case.
What questions should business owners be asking their lawyer throughout the case?
Well, they definitely should be communicating regularly about what's going on. So in terms of the specific questions, you should be talking about things like what has changed during the course of the litigation. Are we still on target with our early assessment and strategy? Given things that have happened, what's the best outcome from here? What are the risks today? Are they the same? Should we continue on this path or should we pivot to something else? And lawyers, obviously, we have a duty to talk to our clients about those things. But to be successful, clients should also be telling their lawyers things that change on their end. So maybe their financial position of their business changed, for instance. Maybe certain goals shifted. Maybe they have a different risk tolerance because of various things as the litigation goes on. And so that conversation, it just should be ongoing. So both lawyer and litigant understand where they are in the process as it moves.
How often should, strategy be revisited in the case?
Well, there's certain triggers, like when things happen, it should be revisited. So I would say those are, new facts come out, maybe the law changes, the other side's behavior shifts or their strategy changes, the court makes a decision. So all those things should be triggers for a conversation. But then also there should be periodic touch points every 3 months or 6 months, depending on the case and the speed. There should be a time when the lawyer and client are just talking about strategy and just setting aside time to communicate about what's happened. Do we need to change our strategy?
What's the risk of staying in a case maybe too long?
Well, there's a cost to it, as we've talked a little bit. So there's diminishing returns. The more time you're in a case, the more it costs. And then there's subtle costs, right? Losing focus on your business. Maybe there's opportunities lost within the course of the litigation as it goes on. So maybe an opponent that you could have settled with early, maybe they file bankruptcy, and now you've lost that case because you've but you've litigated it for too long, right? So you've lost some chance to recover there. So there are, of course, those risks that sometimes they can't be anticipated. So staying on a case too long and pushing it, that does have potential outcomes.
So how do great attorneys help clients avoid all these traps that you've been talking about?
Well, one thing is to just have objective perspective on the practical realities of litigation. Uh, For clients, especially those who do believe they have a very strong case, they need to understand that there are risks that they can't see. Things that can happen that can go sideways that you just don't know about, even if you do have a strong case. I think great attorneys also, they push back on emotional decisions. So a lot of times clients, if they're thinking about settling or quote letting go of a case, sometimes they make emotional statements like it's just not right. They should be apologizing, something along those lines. And I think good lawyers kind of push back on that, especially in business litigation, because this really should be about financial and strategic decisions, not emotional ones. And part of that is identifying potential exit points. We talked about leverage, ways to make sure that you're getting a good outcome at different points in the case. And so being able to, a great attorney, I think, is helping clients getting to those spots where they have potentially very good outcomes, and then counseling them of the risks and rewards of going out that way.
What does a smart exit from litigation look like, though, Kevin?
Sure. So just you know, there are spots in a case where you win, right? You win at trial, you win a summary judgment, and then there's other spots in the case where you maybe don't win an outcome, but you have an opportunity to settle it. So a smart exit from litigation, depending on the type of case, the litigants, the dynamics, it could be an informal settlement, it could be a mediation settlement, or it could be pushing to a spot where you're leveraging the strength of the case to win. And I would say, in general, you want to make sure the outcome aligns with the business goals, the risks are reduced, resources preserved, and then as a counselor to businesses, you want to make sure that the litigation strategy doesn't prevent them from still winning in the marketplace. That they're not spending so many resources going in one direction and fighting this battle that they're losing their business, for instance. So you got to have kind of all those viewpoints when you're looking at when should this business try to get out of litigation.
So what really separates good litigators from great business attorneys?
Well, good litigators, I think they argue well, they know the law, and they're fighting a case. They're trying to win the day. I think a great business attorney is giving practical advice based on experience, understanding what will happen in litigation, but also thinking strategically and objectively about how the case fits into their client's bigger business goals. So you're talking about aligning case strategy with those business goals. And I think a great attorney, whether they're a litigator or not, they'll just tell you things that are difficult to hear. It's not about always being a rah-rah cheerleader. Sometimes it's about saying, this is not the path you should go. These are the problems and risks and issues. So having those really good conversations about, what are the practical realities of the case or the situation of the decision, I think that does make a great attorney.
So, Kevin, if a business owner takes one thing away from this entire conversation and all the information you provided, what should it be?
Well, a couple things there. I think one, litigation is not just about the legal argument. It's about how does it fit strategically, practically, into the overall business, making sure that it's oriented towards business goals. I would say to make sure that you understand in litigation, not all wins are worth the cost, to understanding the costs. And then just make sure that you have the right advisor to help you make very good decisions, whether it's in the courtroom or before you get there, just to make sure that all supports the context of your overall business goals.
Good stuff. Kevin, thank you for your time.
Thank you.
All right. That's it for today's episode of the Business Owners Council, Legal Issues from Growth to Exit. If you want to learn more about Kevin Brick and his team at Brick Business Law and what they can do for you, visit brickbusinesslaw.com. If you found this episode helpful, be sure to subscribe, leave a review, and share it with other business leaders who want to protect their companies and respond strategically when legal issues do come up. Thank you so much, and we'll see you next time.
All right. Thank you.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.